Welcome to The Docket. I'm your host, Corey Snow. This is episode 12. In August 2023, Mark Meadows and Jeffrey Clark were two of 19 people, including Donald Trump, indicted in Fulton County, Georgia, for allegedly attempting to overturn the 2020 Georgia presidential election. Both Clark and Meadows have tried to have their cases removed to federal jurisdiction, arguing that they were acting under color of their roles in the federal government and therefore were immune to prosecution for the charged acts. On August 25, 2023, an amicus curiae, friend of the court, briefing was filed by 8 former judges, prosecutors, and state and federal executive officials, ranging from the Nixon to the Reagan, Clinton, and Bush administrations, in support of remand, meaning to send back to the state court, and opposing Meadows's and Clark's arguments supporting removal. What follows is an audio narration of that amicus brief. Please note that, to improve listenability, most citations are omitted. Those that are not omitted have been simplified to stating only the name of the case. The original document, including all citations and footnotes, is available at a link provided in the show notes. If you are so inclined, please consider supporting my Patreon at patreon.com/docketpod, which allows me more ability to pay Pacer and other court fees to obtain documents for me to narrate for you to listen to. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. United States District Court for the Northern District of Georgia, Atlanta Division. The State of Georgia, Plaintiff, v. Mark R. Meadows, Defendant, and Jeffrey B. Clark, Defendant. Proposed brief for former judges, prosecutors, and state and federal executive officials as amici curiae in support of remand. Table of contents and table of authorities omitted from audio. Interest of amici. Amici are former judges, prosecutors, and state and federal executive officials with experience in both state and federal court, including experience with the Federal Officer Removal Statute, 28 U.S.C. Section 1442, as well as with respect to drawing the line between the official and political activities of the President and other senior executive office holders. As such, amici have an interest in the proper division of responsibility between state and federal courts, as well as in the just enforcement of criminal laws. Footnote 1. No counsel for a party authored in this brief in whole or in part, and no entity or person other than amici and their counsel made a monetary contribution intended to fund the preparation or submission of this brief. Introduction. The Constitution of the United States confers upon the 50 states a compelling interest in prosecuting, in their own courts, criminal interference with their administration of federal elections. See U.S. Constitution, Article 1, Section 4, Ibid, Article 2, Section 1. Consistent with the state's constitutional authority over the integrity of the federal elections they administer, the Federal Officer Removal Statute, 28 U.S.C. Section 1442, does not permit removal here. In conceiving our federal system, the framers insisted that, quote, the fitness and competency of state courts should be allowed in the utmost latitude, end quote. The Federalist No. 81, Hamilton at 485. And, quote, perhaps the clearest example of traditional state authority is the punishment of local criminal activity, end quote. Bond v. United States. To preserve that long-standing tradition, the Supreme Court has recognized a, quote, strong judicial policy against federal interference with state criminal proceedings, end quote. Arizona v. Manipeni. In keeping with that strong judicial policy, removal of a state criminal prosecution to federal court is permitted by the Federal Officer Removal Statute only where a federal officer both 1. Faces criminal charges for conduct arising under color of his office and 2. Identifies a colorable federal defense. See Jefferson County v. Acker, Because neither of those elements is satisfied here, the court should remand these cases to the Fulton County Superior Court. The conduct charged here by the Fulton County District Attorney, interference by Mark Meadows and Jeffrey Clark with the 2020 presidential election in Georgia in order to aid Donald Trump's candidacy, bore no connection to any duty of Mr. Meadows's or Mr. Clark's or Mr. Trump's office. Neither the President nor anyone else in the executive branch has any duty to superintend or participate in a state's election of its presidential electors, and there is no plausible basis for Mr. Meadows or Mr. Clark to claim Supremacy Clause immunity, protection under the First or 14th Amendment, or any other federal defense to the charges. Finally, the purpose of the Federal Officer Removal Statute, to protect federal operations by preventing retribution in state court for locally unpopular exercises of federal authority, would not be served by removal here. To the contrary, removal would be perverse, as this prosecution arises from interference with state government operations and seeks to vindicate Georgia's voice in a federal election, the very contest from which federal authority flows. Footnote 2. Although the state has not yet moved for remand in the State of Georgia v. Jeffrey B. Clark, amici agree with the state that Mr. Clark's notice of removal is, like Mr. Meadows', deficient. Amici therefore submit this brief in support of remand in both cases. Argument. 1. Mr. Meadows and Mr. Clark were indicted for electioneering conduct unrelated to any duty of their offices. The Federal Officer Removal Statute provides that an officer may remove a state prosecution only if it is, quote, for or relating to any act under color of his office, end quote, 28 U.S.C. Section 1442A1. That requirement is not remotely met here. Mr. Meadows and Mr. Clark are charged for their efforts to pressure election officials in Georgia to award the state's electoral votes to Mr. Trump in the 2020 presidential election, as well as for supporting similar pressure applied by Mr. Trump himself. None of that conduct was grounded in any official duty of either Mr. Meadows' position, White House Chief of Staff, or either of Mr. Clark's positions, Assistant Attorney General for the Justice Department's Environmental and Natural Resources Division and Acting Assistant Attorney General for the Justice Department's Civil Division. Indeed, neither the Constitution nor any other source of federal law affords these office holders any role in the selection of a state's presidential electors. To the contrary, the executive branch is deliberately and understandably walled off from that selection process. There is thus no basis for removal. A. Quote, the defendant has the burden of proving by a preponderance of the evidence that the requirements for removal jurisdiction have been met. End quote. County of San Mateo v. Chevron Corporation. Historically, defendants invoking the Federal Officer Removal Statute have had to show, quote, a causal connection between the charged conduct and asserted official authority, end quote. Acker. In other words, the prosecution had to be, quote, based on or arise out of, end quote, conduct the officer performed, quote, under authority of federal law in the discharge of his duty and only by reason thereof, end quote. Maryland v. Soper. In 2011, Congress amended the Federal Officer Removal Statute by inserting the words, or relating to, in the phrase, quote, for or relating to any act under color of such office, end quote. Removal Clarification Act of 2011. While courts have disagreed on the precise effect of that amendment, every court that has applied the amended statute has agreed that it permits removal only where a case is at least, quote, connected or associated with acts under color of federal office, end quote. Latiolais v. Huntington Ingalls, Inc. That includes the 11th Circuit, which interprets the phrase relating to as requiring at least a connection or association between the charged conduct and some official duty. Caver v. Central Alabama Electric Cooperative. Courts also agree that the connection between the charged conduct and an official duty may be, quote, too remote, end quote, Minnesota by Ellison v. American Petroleum Institute, or, quote, too tenuous to support removal, end quote, Mayor and City Council of Baltimore v. BP plc. And in a criminal case, as here, a defendant seeking removal must make a more detailed showing of the required connection owing to the, quote, more compelling state interest in conducting criminal trials in the state courts, end quote. Willingham v. Morgan. Footnote 3. Mr. Clark is wrong to assert that his notice of removal, quote, removes not just the Fulton County action itself, but also the special purpose grand jury proceedings that preceded, end quote, the indictment. The only action pending against Mr. Clark is a criminal indictment. As he concedes, the special purpose grand jury, which never charged him with anything, quote, was dissolved on January 9, 2023, end quote. There is thus no other proceeding over which this court could assume jurisdiction. B. Neither Mr. Meadows nor Mr. Clark can identify any official duty bearing any connection to the conduct for which he is charged. Both are charged with efforts to manipulate Georgia officials who had roles in administering the presidential election in their state. Mr. Meadows for attempting to manipulate the Georgia Secretary of State. See indictment at 50, count 1, Act 112, 87, count 28, and the Secretary's chief investigator, see Ibid at 44, count 1, Act 93, 45, count 1, Act 96, and Mr. Clark for attempting to manipulate the governor, the Speaker of the Georgia House of Representatives, and the President pro tempore of the Georgia Senate, see Ibid at 45, count 1, Act 98, 46, count 1, Act 99, 50, count 1, Act 110, 83, count 22. Mr. Meadows is also charged with attempting to infiltrate a signature match audit taking place in Cobb County, Georgia. See Ibid at 44, count 1, Act 92. And while Mr. Clark's position qualified him as a federal officer for purposes of the removal statute at the time of his alleged conduct, this brief takes no position on the unsettled question whether the President or White House Chief of Staff qualifies as a federal officer under the statute. Quote, not every act of or on behalf of a federal officer is an act under color of office, end quote. New York v. Trump. See also Clinton v. Jones. The acts charged here certainly were not under color of either man's office. 1. Neither the President, his Chief of Staff, nor the Department of Justice has any duty, or authority for that matter, to superintend state election officials' administration of a federal election in the manner alleged. As the Supreme Court has explained, the Constitution, quote, empowers the states, end quote, and Congress to, quote, regulate the conduct of federal elections, end quote. Roundbush v. Hartke. Emphases added. See also U.S. Constitution, Article 1, Section 4, Elections Clause, Ibid, Article 2, Section 1, Electors Clause. Likewise, while the Electoral Count Act assigns duties to various congressional officials, quote, the presiding officer, i.e., the Vice President acting as President of the Senate, the Speaker of the House, the Senators, the Representatives, the tellers, who count electoral votes, and others, end quote. It prescribes no role for the President, the White House Chief of Staff, or the U.S. Department of Justice. United States v. Sandlin. To the extent the Department of Justice has any responsibilities touching on federal elections, they do not include superintendents of the state's administration of federal elections, and in any event are not within the offices Mr. Clark held. Nor did the Constitution's Take Care Clause vest Mr. Trump, Mr. Meadows, or Mr. Clark with any relevant duty. That is because the clause, quote, does not extend to government officials over whom the President had no power or control, end quote. Thompson v. Trump. Emphasis omitted. The clause thus did not confer on Mr. Trump, Mr. Meadows, or Mr. Clark any duty to manage or direct the congressional officials with roles prescribed by the Electoral Count Act. those officials were members, quote, of a co-equal branch not subject to executive branch control, end quote, ibid, much less to manage or direct state election officials. This is not by accident. It is instead by design that, quote, our country has a highly decentralized system of election administration in which states and localities are primarily responsible for regulating and managing elections, end quote. Vote Forward v. DeJoy. Indeed, the framers ensured, quote, that the election of the president, end quote, would be, quote, well guarded from any sinister bias, end quote, not only by fostering a, quote, detached and divided, end quote, process in each state, quote, but also by excluding from eligibility, end quote, to serve as presidential electors, quote, all those who from situation might be suspected of too great devotion to the president in office, end quote. The Federalist, number 68, Hamilton. See also U.S. Constitution, Article 2, Section 1, Clause 2. Surely, then, the framers did not contemplate supervision of a presidential election by a sitting president himself or senior members of the executive branch. As another court recently concluded, therefore, Mr. Trump's interference with state election officials cannot, quote, possibly constitute executive action in defense of the Constitution, end quote. Michigan Welfare Rights Organization v. Trump. The same goes for Mr. Meadows' and Mr. Clark's interference, as well as their support of Mr. Trump's. And it makes no difference whether Mr. Trump, Mr. Meadows, or Mr. Clark believed they were addressing suspected voter fraud or election irregularities in Georgia. Suspicions, it bears noting, that have never been substantiated. As in the case just cited, Mr. Trump and Mr. Meadows and Mr. Clark cannot, quote, offer any reason to believe their efforts to expose election fraud were part of any executive effort, end quote. Ibid. 2. Even if the law were otherwise, such that the President, and thus perhaps his Chief of Staff, or the Justice Department, particularly the divisions Mr. Clark headed, had a role in ensuring that state election officials fairly administer the presidential election in their state, that is not what Mr. Meadows or Mr. Clark is alleged to have done. The required connection between the alleged conduct and any official duty would therefore still be missing, or at least too remote to support removal. Ellison. Mr. Meadows and Mr. Clark are charged for their efforts to, quote, change the outcome of the election in favor of Trump, end quote. Indictment at 14. For efforts, that is, in service of Mr. Trump's candidacy. Such conduct constitutes electioneering. It is not, quote, connected or associated, end quote, with any official duty. Latio lay. Emphasis omitted. Footnote 4. Count 28 alleges that on January 2, 2021, Mr. Meadows and Mr. Trump, quote, unlawfully solicited, requested, and importuned Georgia Secretary of State Brad Raffensperger, end quote, to, quote, unlawfully influence the certified returns for presidential electors, end quote. This communication's purpose was unquestionably to aid Mr. Trump's candidacy. Mr. Trump told Secretary Raffensperger that he needed to, quote, find 11,780 votes, end quote. In Mr. Trump's words, exactly, quote, one more than, end quote, he needed as a candidate to win in Georgia. Transcript, President Trump's phone call with Georgia election officials. New York Times, January 3, 2021. The precise tailoring of this demand leaves no doubt that it was made in service of Mr. Trump's candidacy, not in any official duty. What's more, the way Mr. Trump prefaced the demand, quote, all I want to do is this. I just want to find 11,780 votes, end quote. Ibid, emphasis added, makes clear that the communication was made exclusively to aid Mr. Trump's candidacy. The same is manifestly true of the conduct of Mr. Clark charged in Count 22, composing a baldly false representation and importuning his superiors to send it in order to threaten Georgia officials is nothing other than election interference for a purely political and personal objective. All three branches of the federal government agree that electioneering is not an official function. Congress distinguished in the Hatch Act between electioneering activities and official conduct, applying restrictions on federal employees' activities in the former category, but not the latter. See Office of Special Counsel, Federal Hatch Act Advisory, Candidate Visits to Federal Agencies 1 and 2. The executive branch's Office of Legal Counsel does not consider expenses for campaign travel to be official expenses. Payment of expenses associated with travel by the President and Vice President. And federal courts routinely distinguish between official and campaign conduct. The 11th Circuit, for example, has held that the management of a sheriff's campaign webpage was not state action because, quote, acts of officers in the ambit of their personal pursuits are not done under color of law, end quote. Charoudatan v. Darnell, quoting Myers v. Bowman. As another court held in a similar context, quote, the opposite conclusion would impermissibly stretch the definition of under color of law, end quote. Salkin v. LaBrosse. Put simply, this prosecution is not, quote, for or relating to any act under color of Meadows or Clark's office, end quote. 28 U.S.C. Section 1442A1, because neither the Office of President and a fortiori the Office of White House Chief of Staff, nor the Justice Department, and particularly the offices Mr. Clark held, has any duty or even authority to participate in the administration of a state's presidential election as alleged here. And even if those offices had such a duty, the charged conduct still would not relate to that duty because, quote, the office of the President has no preference for who occupies it, end quote. Thompson, and the alleged interference with the presidential election in Georgia clearly evinced such a preference. At the very least, any connection to an official duty is, quote, too tenuous to support removal, end quote. Mayor and City Council of Baltimore. Neither Mr. Meadows nor Mr. Clark can make the requisite detailed showing otherwise. Willingham. Remand is therefore required. 2. Mr. Meadows and Mr. Clark have no colorable federal defense. Independently, to remove a case against him, a federal officer must, quote, raise a colorable defense arising out of his duty to enforce federal law, end quote. Willingham. The Supreme Court imposed this separate requirement because the court, in its words, quote, retains the highest regard for a state's right to make and enforce its own criminal laws, end quote. Manypenny. To respect that right, the court held, federal officer removal of a prosecution under state law must be, quote, limited to assuring that an impartial setting is provided in which the federal defense of immunity can be considered, end quote. Ibid. Mr. Meadows and Mr. Clark fare no better on this requirement than on the requirement discussed in Part 1, for essentially the same reasons discussed there. A. Mr. Meadows and Mr. Clark's principal purported federal defense is that their conduct is shielded by Supremacy Clause immunity. See Meadows' notice of removal, Meadows' motion to dismiss, Clark notice of removal. But no such immunity exists where, quote, it cannot reasonably be claimed that, end quote, the officer's conduct was, quote, in the performance of a duty imposed by federal law, end quote. United States, ex rel. Drury v. Lewis, emphasis added. None of the conduct for which Mr. Meadows or Mr. Clark is charged arose from or is related to any duty imposed on him by federal law. As explained in Part 1, no federal statute or constitutional provision empowers, let alone requires, the President, his Chief of Staff, or the Justice Department divisions Mr. Clark headed to interfere in a state's presidential election. The reasoning of Thompson v. Trump is instructive. The court there held that Mr. Trump had no official duty to urge the Vice President or members of Congress to violate their own federal law duty to certify electoral votes on January 6, 2021, and thus he was not immune from liability for such exhortation, because, as noted, the President's duties under federal law, including the Constitution's Take Care Clause, do, quote, not extend to government officials over whom he has no power or control, end quote. Ibid. Just as Mr. Trump had no power over the Vice President or members of Congress performing their prescribed roles in the certification process, so too he and Mr. Meadows and Mr. Clark had no power over Georgia officials administering the presidential election in that state. And just as the Thompson Court explained that the Electoral Count Act, quote, prescribes no role for a sitting president, end quote, in the tabulation of votes in the Electoral College, Ibid, no statute or constitutional provision permits any role for the relevant federal offices in the administration of a particular state's determination of those votes. The 11th Circuit has held, moreover, that Supremacy Clause immunity does not extend to an officer who, quote, acted because of any personal interest, end quote, rather than, quote, to do his duty, end quote, under federal law. Baucom v. Martin. That is the situation here. Again, Mr. Meadows and Mr. Clark are charged for their efforts to, quote, change the outcome of the election in favor of Trump, end quote. Indictment at 14. In other words, for their efforts to aid Mr. Trump's candidacy. Because the charged conduct constitutes electioneering, it is, as explained in Part 1, personal and not official. B. In his motion to dismiss, Mr. Meadows invokes the First and 14th Amendments as, quote, contingent defenses, end quote, should this court reject his claim to Supremacy Clause immunity. Meadows' motion to dismiss. To begin with, however, even if there were any merit to these defenses, and as explained below, there isn't. It is unlikely either could satisfy the colorable federal defense requirement for officer removal. As noted, the Supreme Court has both required officers to, quote, raise a colorable defense arising out of their duty to enforce federal law, end quote, Willingham, emphasis added, and held that federal officer removal must be, quote, limited to assuring that an impartial setting is provided in which the federal defense of immunity can be considered, end quote. Manypenny, emphasis added. Mr. Meadows has not shown that either of his contingent defenses satisfies these requirements. In any event, Mr. Meadows has no plausible claim to a defense under the First or 14th Amendment. Mr. Meadows' First Amendment defense ignores the, quote, historic and traditional, quote, exception to the protection of free expression for, quote, speech integral to criminal conduct, end quote. United States v. Stevens, citing Gaboni v. Empire Storage and Ice Company. That disregard is particularly striking given that, quote, speech integral to criminal conduct is now a standard item on lists of First Amendment exceptions, end quote. Volach, The Speech Integral to Criminal Conduct Exception, 101 Cornell Law Review, 2016. Mr. Meadows contends specifically that his and Mr. Trump's January 2, 2021, quote, discussion with the Georgia Secretary of State, end quote, which is the subject of Count 28, see Note 4, supra, receives First Amendment protection because it was, quote, about public issues of political importance, end quote. Meadows' motion to dismiss. But the indictment alleges, at 87, that discussion was part of Mr. Meadows' charged crime of soliciting the Georgia Secretary of State, quote, to engage in conduct constituting the felony offense of violation of oath by public officer, OCGA Section 1610(1), end quote. And the Supreme Court has specifically held that solicitation, i.e. speech, quote, intended to induce or commence illegal activities, end quote, is, quote, undeserving of First Amendment protection, end quote. United States v. Williams. That precedent squarely forecloses Mr. Meadows' First Amendment defense. Equally groundless is Mr. Meadows' claim, motion to dismiss, that his prosecution violates due process because the statutes under which he is charged, quote, are unconstitutionally vague as applied to the charges against, end quote, him. Mr. Meadows offers no actual argument, let alone a colorable one, as to why that is so. See Ibid. And it obviously is not. Take, for instance, the conduct on which Mr. Meadows' motion focuses, his and Mr. Trump's, quote, discussion with the Georgia Secretary of State, end quote. Ibid. As noted that discussion was in fact an exhortation that Secretary Raffensperger, the officer sworn to faithfully certify Georgia's election results, quote, find 11,780 votes, end quote, to swing the election for Mr. Trump. Transcript, President Trump's phone call with Georgia election officials. It is hard to imagine a clearer example of soliciting a public officer to violate his oath. Mr. Meadows' suggestion that he lacked fair notice that such an exhortation could constitute criminal solicitation is simply absurd. C. Mr. Clark's unsupported invocation of the First Amendment fails for the same reasons, and while he lists other defenses, see Clark Notice of Removal, he fails to discuss them, despite his, quote, burden of proving that the requirements for removal jurisdiction have been met, end quote. County of San Mateo. And in any event, they are patently inapplicable. 3. Removal here would not serve the purpose of the Federal Officer Removal Statute. The Federal Officer Removal Statute reflects Congress's concern that because federal officers may be required by law to take official actions that are unpopular with local populations, they could face unjustified state charges, which could, in turn, impede federal operations. That concern is not remotely implicated here. The removal statute's history makes that plain. Congress enacted the first two versions to prevent state laws from defeating the enforcement of federal trade policy. The first version, quote, was part of an attempt to enforce an embargo on trade with England over the opposition of the New England states, where the War of 1812 was quite unpopular, end quote. Willingham. The second, quote, was passed in consequence of an attempt by one of the states of the Union to make penal the collection by United States officers within the state of duties under the tariff laws, end quote. Tennessee v. Davis, 1879. As the Supreme Court later explained, quoting Senator Daniel Webster's views from the time of the second version's enactment, quote, where state courts might prove hostile to federal law, and hence to those who enforced that law, the removal statute would give a chance to the federal officer to defend himself where the authority of the law was recognized, end quote. Watson v. Philip Morris Companies. That remains a core purpose of the removal statute. During the Civil War, Congress revised the statute both to permit removal of actions brought against officers during the war and to improve the capacity of the federal government to collect revenue. See Act of March 3, 1863. Shortly thereafter, the Supreme Court explained that without the removal statute, quote, the operations of the federal government could at any time be arrested at the will of one of its member states, end quote. Davis. In the latter half of the 19th century, too, then, Congress and the court understood the statute as a means to prevent local populations from impeding federal operations. More recently, the Supreme Court has reaffirmed that the removal statute's, quote, purpose is to protect the federal government from the interference with its operations that would ensue, end quote, were a state able to arrest and try a federal officer for, quote, acting within the scope of his authority, end quote. Watson. Such interference would flow from the fact that, quote, state court proceedings may reflect local prejudice against unpopular federal laws or federal officials, end quote. Ibid. To say the least, the statute's purpose to prevent interference with federal operations would not be served by removing the charges against Mr. Meadows or Mr. Clark from Georgia State Court. These prosecutions do not threaten to impede any federal policy or prevent the federal government from carrying out its operations. The charges are not unjustified retribution for a legitimate exercise of federal authority. It is Georgia, not the federal executive, that is responsible for administering the state's selection of its presidential electors, including assuring the integrity of that election. Allowing it to do so, including by leaving it to the state's own courts to adjudicate any alleged violations of the state's criminal laws, is in no way contrary to, and in fact is fully consistent with, the purpose of the federal officer removal statute. The Constitution entrusts the administration of federal elections to the states. It deliberately insulates such administration from the president and his staff. Consistent with that constitutional design, the federal officer removal statute does not permit removal here. Conclusion: the court should remand these cases to state court. August 23, 2023. Seth P. Waxman, Daniel S. Volchok, Joseph M. Meyer, Wilmer Cutler Pickering, Hale and Dorr, LLP. Address, phone number, and email address omitted from audio. Fred Wertheimer, Democracy 21 Education Fund. Address, phone number, and email address omitted from audio. Respectfully submitted. Signed, John Thomas Morgan III. John Thomas Morgan III, 522-675. J. Tom Morgan, Attorney, LLC. Address, phone number, and email address omitted from audio. Appendix. List of amici curiae. Donald B. Iyer, U.S. Deputy Attorney General in George H. W. Bush Administration, 1989 to 1990. U.S. Principal Deputy Solicitor General in Reagan Administration, 1986 to 1988. U.S. Attorney for the Eastern District of California in Reagan Administration, 1981 to 1986. John J. Farmer, Jr., Acting Governor of New Jersey, January 8, 2002. New Jersey Attorney General, 1999 to 2002. Chief Counsel to Governor Whitman of New Jersey, 1997 to 1999. Deputy Chief Counsel to Governor Whitman of New Jersey, 1996 to 1997. Assistant U.S. Attorney for the District of New Jersey in George H. W. Bush and Clinton administrations, 1990 to 1994. Charles A. Freed, Associate Justice of the Massachusetts Supreme Judicial Court, 1995 to 1999. U.S. Solicitor General in Reagan Administration, 1985 to 1989. Special Assistant to the U.S. Attorney General in Reagan Administration, 1984 to 1985. Stuart M. Gerson, Acting U.S. Attorney General in Clinton Administration, 1993. U.S. Assistant Attorney General for the Civil Division in George H. W. Bush and Clinton administrations, 1989 to 1993. Assistant U.S. Attorney for the District of Columbia in Nixon and Ford administrations, 1972 to 1975. J. Michael Ludig, Judge of the U.S. Court of Appeals for the Fourth Circuit, 1991 to 2006. U.S. Assistant Attorney General for the Office of Legal Counsel in George H. W. Bush Administration, 1990 to 1991. Assistant Counsel to President Reagan, 1980 to 1981. Alan Charles Raoul, General Counsel to the U.S. Department of Agriculture in George H. W. Bush Administration, 1989 to 1993. General Counsel to the Office of Management and Budget in Reagan Administration, 1988 to 1989. Associate Counsel to President Reagan, 1986 to 1988. Stanley A. Twardy, Jr., Chief of Staff to Governor Weaker of Connecticut, 1991 to 1993. U.S. Attorney for the District of Connecticut in Reagan and George H. W. Bush administrations, 1985 to 1991. William F. Weld, Governor of Massachusetts, 1991 to 1997. U.S. Assistant Attorney General for the Criminal Division in Reagan Administration, 1986 to 1988. U.S. Attorney for the District of Massachusetts in Reagan Administration, 1981 to 1986. This concludes this episode of The Docket. I hope you enjoyed this narration. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.